Good evening, everyone. My name is Izzy, and I'd like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing coercive control, and we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to that community. Now, I'd like to introduce our presenter today, Rich Harris. Rich is the managing partner of the Harris Law Firm, one of Colorado's largest divorce and family law firms. Passionate advocate who prioritizes personal attention, Rich has been named among the best lawyers in America, Colorado super lawyers, and a top lawyer of Colorado by the Denver Post. Outside of the courtroom, Rich has published articles across a range of family law topics, as well as co-authoring the Colorado Family Law Desk Book. He's also actively involved in many international and domestic humanitarian organizations, including the Road to Hope, a nonprofit dedicated to promoting development in Haiti. All right, Rich, without further ado, I'll turn it over to you.
Well, thank you very much, Izzy, for that very kind introduction. Thanks to each and every one of you, wherever you're joining us from. We have a very important, critical topic to present tonight. It's the first time we've done this presentation, and that's because this is a brand new law that we're all experiencing right now. For a lot of reasons, we think it's a very important and good development in the state of Colorado, but it's not without its controversy and not without its difficulties when it comes to family law litigation. There are lots of folks on the call tonight. Thank you again for joining us. There's certainly a lot of interest in this topic, and we've got a lot to cover. So without further ado, we're going to plunge right in. First of all, here's how I'm going to organize my remarks for tonight. We're going to talk about the new law, identify it, and talk about why it matters and how it impacts actual family law cases. In conjunction with that, we'll talk about the definitions of coercive control, coming right from the statute. And then we will go over a number of different examples, including the impacts of these very concerning, troubling behaviors. Then, time permitting, we'll answer as many questions as you might have tonight. Let me say the following before we get really into it, however. This is a very big subject. It's a controversial subject. Certainly any conversation about domestic violence is a big and difficult topic and a very serious topic. By no means am I going to be able to cover everything. My point, however, is to provide an overview and some practical things to be thinking about as folks are either in these awful situations, whether they're victims or they're being accused of these behaviors, and talk about how one might deal with some of this stuff, both before court proceedings and during court proceedings. Okay, so let me start with a bit of background here. Where did this term of coercive control come from? Why is it so important? So we'll talk in a few minutes about some of the definitions of coercive control. But the idea comes from the notion that, first of all, domestic violence is an incredible scourge, not only in Colorado, but all around the country. In fact, all around the world, we know, and I'm involved with a lot of international legal organizations, and we know this stuff is going on everywhere. I call it a scourge by design. It is rampant. It is awful. It is terrible. I don't have any hard data in terms of whether domestic violence is increasing as a phenomenon or not. I'll leave that to the social scientists to opine on. It's certainly being reported more. That's a good thing. It's probably still way, way underreported, even though it's growing in prevalence and it's being talked about as it should be. Now, Coercive control is a subcategory, if you will, of domestic violence or domestic abuse. And the idea is that domestic abuse takes many, many different forms. And not all of those kinds of forms manifest themselves into physical behaviors. So the traditional notions of domestic abuse, which involve physical injuries primarily, was not enough to encompass the kinds of behaviors that we as a society ought to be concerned about in terms of protecting people and protecting their children. So that's where the idea of broadening the definition of domestic violence into areas like coercive control. Coercive control was first coined by an American sociologist, and his name is Evan Stark. And he wrote a seminal book on the subject, and he used the term coercive control in the title. It's available still. It's an important groundbreaking piece of research. I just checked prior to tonight. It's available on Amazon if you're interested. This sociologist, who also had experience both as a social worker and as somebody who ran a domestic violence shelter, the notion was that there was an enormous problem of manipulation and control and coercion and domination behaviors that didn't always include physical abuse. And they usually did not include physical abuse. Nevertheless, the ramifications of these behaviors on victims are long-term, they are significant, and they are profound. I'm not going to make any value judgments about what is worse because that's beyond defining. It's all terrible. But the impact on the victims and the intents of the perpetrators are similar, whether you're controlling or manipulating somebody by physically striking them, or you're threatening them and making them behave in such a way that is under the perpetrator's thumb, if you will. So we had a sea change in Colorado just last summer. In August of last summer, the Colorado legislature enacted a new piece of legislation where, for the first time in our statutes, we included the term coercive control within the definitions of domestic violence. And we defined what coercive control is. And in the statute, it lists more than a dozen of different kinds of behaviors that fall under coercive control, not intended to include everything, but it includes many of the most common behaviors. And it's codified in the statute as of August 2024. It's not an exaggeration for me to say, as a practitioner, that it's impacting divorce and child custody cases every single day in our state. Most of the lawyers in our firm, in just the few months this has been in effect, have had cases where this issue was raised one way or the other. It's played significant roles in several of the cases I've handled. And again, we're talking about something that just went into effect less than a year ago, less than 6 months ago, actually. So generally, what coercive control means, there are a couple of key pieces of this. It's a type of domestic violence, and it's perpetrated against somebody who's been in an intimate relationship with another person. It is a method of control and manipulation that may not involve physical manifestations of abuse where the victim is in an intimate relationship. That's what it means broadly. Why does it matter? Well, it's huge why it matters. It matters because when the Colorado legislature included this as a component of the domestic violence statutes, the law right away recognized that it had to be considered in the most important family law cases that judges hear, namely child custody cases and divorce cases, whether or not they involve children. Okay, so domestic violence is something that has always been relevant in those kinds of cases. The change is that domestic violence now includes coercive control. Okay. So what is the actual definition when it comes to Colorado law? Let me say a little bit about why I talk about Colorado law as being of primary importance. Family law is a creature of state law. What that means is every state has a different set of statutes governing family law cases. Okay. There are general notions nationally of children's best interests, for example, and maintenance or alimony. There are some general concepts that apply from state to state, and states handle them differently. But in terms of the actual statutes judges must consider, judges are 99% of the time focused on what's written in the Colorado statutes only, and the case law, which means judges' decisions that interpret that body of statutes. Okay, so coercive control. It's codified here, 14-10-124. 1.3a. Izzy, maybe you can put a link to the statutes in the chat here. If you've been to one of our webinars before, you've probably heard me talk about the fact that I believe the law shouldn't be so mysterious and it shouldn't be the province of only lawyers and judges. If you're involved in any proceeding before the family law courts, especially a family law proceeding, in my humble opinion, it behooves you to become as informed as possible. Whether you have a lawyer, by the way, or not, the more you know, the more you're familiar with in terms of the terminology, in terms of seeing the actual language that judges are going to be using to decide your life and your kid's life, I think is an important thing to do. So I encourage you to click on that link. I think it's fairly self-explanatory in terms of how to find the statutes, how they're organized. If you have any problems, please just give us a call. We'll be happy to walk you through it. But this particular definition of coercive control is in what we would term section 124. 124 is the best interests of the child statute. The statute on children's best interests now is where you're going to find this definition of coercive control. In general, it's a pattern of threatening, humiliating, intimidating, including assaults or other abuse intended to harm, punish, or frighten an individual. It includes patterns of behavior that control and humiliate. So these behaviors do things like deprive somebody of freedom, strip away their dignity, violate their integrity or their reputation. All of these behaviors are considered coercive control. So let's get into a little bit more of the detail. So coercive control includes the following. And here I'm going to quote directly from the statute because these are the dozen or so items that are considered coercive control. Again, not a comprehensive list. It might exist if it meets those broad definitions I spoke about a moment ago, but here are some specifics. Isolating the individual from friends and family. Monitoring, surveilling, regulating, controlling the individual's or the individual child's finances, economic resources, access to services. Monitoring, surveilling, regulating, or controlling the individual's or individual's children or relatives' activities, communications, movements, including through technology. We'll talk a little bit more about that in a moment. Name calling, degrading, demeaning. And again, it can be directed at the victim or the primary victim, which is typically the spouse, or it could be directed at the children or other relatives. If you have somebody within your household who is being subjected to verbal abuse and humiliation, and that victimization is occurring in front of you, and you believe it's happening to intimidate you, you are the victim of domestic abuse. Moving on, threats, threatening to harm or kill the individual or other folks in their circle, relatives and children. Using weapons, displaying weapons in a threatening manner. Suicidal ideations, not the ones that come from a depressive, reaching out for help standpoint, but the ones that involve stating those things to scare the victim, to make the victim afraid to do something because the perpetrator is threatening suicide, to intimidate somebody. We see this. It is incredibly disturbing, and it's happening. It has been happening for a long time. Threatening pets. I'm going to talk more about this, but it is no coincidence that the notion of animal threats comes up again in the context of domestic abuse. Fact is, we've known for many decades that when a pet is harmed or threatened within a home, there's a really high statistical probability that there is other domestic violence that is happening within that same household. Okay. In fact, the ASPCA, the American Society for the Protection of Children and Animals, and I misspoke a bit on that, but those are the words. Okay. The organization that is the umbrella for protecting pets used to also focus on children because there are abuses that are related, sadly. So the abuse might be to the animal, which is sick in and of itself, obviously. But when it's being done or it's being threatened to intimidate, make afraid the other folks in the family, that is coercive control. Threatening to publish embarrassing or humiliating things. This has been going on for a long time, and sadly, this is I'm sure you've heard rampant in our society and in other contexts. Sad situations involving school bullying, for example, shaming, that kind of thing. But when somebody does it to an intimate partner in the family, or actually it doesn't have to be in the family, an intimate partner, somebody with whom they have an intimate relationship, any form of shaming, including in particular Shaming involving sexually explicit photos or videos, or merely threatening to publish this stuff, or threatening to publish sensitive, personal, sexual information, that is coercive control. Damaging the individual's property or household goods. Now, if you're in a home and somebody breaks the couch, or breaks windows, or throws a remote control through a TV screen, that alone can be charged as domestic violence. That physical act of abusing property is in and of itself a crime. But when it's done to intimidate or to threaten, then it's an additional category of domestic abuse. It's coercive control. Threatening the individual or the individual's child or relative with legal proceedings. This was happening even before there was such a heightened, or there is now such a heightened conversation around immigration, and a lot of fear amongst a number of communities around, the scrutiny, around deportation, wherever you stand on that side of the political battle. When somebody does that to an intimate partner, or threatens to do that to an intimate partner or member of their family, with the goal of intimidating or humiliating or making somebody fearful, it's domestic violence. It's coercive control. The same would be true, by the way, with any threat for criminal prosecution, particularly false threats. Threats to turn somebody into a licensing board for their profession, threats to turn somebody into authorities for committing some sort of crime. If it's done to intimidate, to humiliate, to coerce, again, it can be considered coercive control. Forcing somebody to engage in criminal conduct or child abuse. That's fairly obvious. If you're doing that, not only is that a crime, but if you're doing it to intimidate, or you're threatening to make somebody do something like that, coercive control. Okay. So 1410-124. Again, this is codified in the best interest statute. I'm emphasizing this again because this is how important the law takes it. Okay. When you define something like this in the very statute that is sort of the judge's Bible on how to handle decision making involving kids and visitation or parenting time for children, you are elevating it to a paramount issue for judges to look at, and they are doing so. This is the statute, the best interest of the child, like I said, that governs allocation of parental responsibilities matters. That means child custody, decision-making authority, as well as parenting time, which is visitation. The law says that you must consider any form of domestic violence or domestic abuse when deciding issues of child custody decision-making and parenting time, visitation. Okay, you must consider this, and in many cases, if you have proven by a preponderance of the evidence that domestic violence exists, which now includes coercive control, you are right away disqualifying the majority of couples from joint decision making. The court has to make extraordinary findings to make an order for joint decision making if the court finds that one of the parents is a perpetrator of domestic violence. That's how important it is. Okay. So the ramifications of something like this are enormous. So we talked about child custody proceedings, visitation proceedings. It's also an element now in county court restraining orders, what we call protective orders. You can obtain a protective order in the county in which you live, whether or not you file for divorce or child custody, if you are if you show that you are in imminent harm, you've been threatened, you've been a victim of violence, and you're likely to be victimized again unless the court restrains the perpetrator. Now, domestic violence clearly includes coercive control. It's going to be critical in a lot of these cases if somebody obtains a protective order, and that protective order, the way it works is that you get a temporary protective order first, then the other side shows up and they get to try to defend themselves. If the protective order is made permanent, I can tell you it's going to have a profound impact in future proceedings for divorce or child custody. Profound impact. Okay. And it could even impact how property and finances are divvied up in a dissolution of marriage proceeding. Okay. It may even form the basis for a criminal charge. What I want to say about the criminal piece, however, is that there is no standalone crime of coercive control. So, for example, you can be charged with a variety of domestic violence crimes that are specified, such as harassment or physical abuse. Those are standalone crimes. You won't find a standalone crime for coercive control, but the elements of coercive control that we just talked about, and we're going to talk about a bit more, all of those elements could form the basis of a variety of other criminal charges. And they do, and they are being prosecuted in courts around our state right now. So let's get into some of the examples here. And I'm going to give some examples here, and then I'm going to flip to some of the impacts on victims, and we're going to go back and forth a bit here. So let's talk about isolation as a form of coercive control. Okay. If you're in an intimate relationship with somebody and that somebody is incredibly jealous and controlling and prevents you, either physically or by means of intimidation, from having social relationships with friends, from having social activities like going to the gym where you might meet other potential romantic partners. Or whether, the reality is in most of these cases, most people just want to have a normal life and have an ability to do things outside of the house. It is the paranoia and the, in my opinion, illness, personality disorders in the perpetrator that prevents somebody from engaging in those kinds of relationships. Okay. Another form of coercion is controlling the money. Now, I don't mean the kinds of examples that are, even perhaps extreme examples where somebody is concerned the other party is spending too much and they limit their credit card use, or maybe they say that they need to come home at a certain time or not go on certain trips. Maybe they even say you can't spend more on clothing beyond X per month. That's not what we're talking about. What we're talking about is cutting somebody off from access to money, not giving them a credit card or giving them a credit card with an absurdly low limit, let's say a $200 limit, We've seen that. Or making sure that the bank accounts are titled only in one spouse's name, hiding financial records so the other, I use the term spouse, forgive me, the other partner, this doesn't have to be only in a married relationship, of course. The other partner can't access or find ways to access money. They can't travel, they can't really do anything. That's a form of control. Stalking behaviors of all different kinds. And as the technology has advanced, and as people become more devious and more manipulative, perhaps, we see new things all the time. It might be installing tracking devices in the other party's vehicle and the other party's clothing and the other party's luggage. You might install, or somebody might install tracking devices, believe it or not, in a child's toy or a child's backpack when he or she visits the other parent. Sounds crazy, sounds extreme. I've seen it in cases. It is happening. Um, Implanting tracking devices on a vehicle, I think I mentioned. More traditional things like literally installing listening bugs. We've seen situations where somebody was concerned that there were listening devices planted in light fixtures or underneath furniture. Sky's the limit. Stalking behaviors, following behaviors. Some vehicles I know are very easy to track, especially if they're on the same technology plan. A lot of couples use this in order to just have an idea where the other parent is. Maybe they're coordinating kid pickups. They're wondering how long it's going to take for somebody to be somewhere. It's not what I'm talking about. That stuff is okay. It's when you use it in a manipulative, controlling way. That's when it becomes abuse. Okay. So what about some of these psychological impacts here? One of the things we see a lot of, you've probably heard this term, it's gaslighting. It's where somebody is making statements, they're false statements, but they're done in such a way as to cause the listener to doubt him or herself. The perpetrator implants false narratives or uses false narratives in order to intimidate, in order to control, in order to lead to self-doubt, to confusion. As you can imagine, folks, a lot of these behaviors don't happen in isolation. We've seen cases where there's gaslighting plus device tracking, plus money controls. When you're planting false narratives, you're doing it in a way that's persuasive or that is so overwhelming, especially if the victim has been victimized in other ways and essentially trained to behave in certain ways as a result of this terrible abuse. They might be very prone to this gaslighting kinds of behaviors. Any kinds of coercive control, when they're done, they're going to cause fear and anxiety. That's used in all sorts of ways. It's used for creating an advantage in litigation. It's used for creating an advantage in a negotiation. We law knows, the law says that you shouldn't be reaching any agreements unless there's full disclosure and unless they're voluntary, not under duress. If one of the parties is a victim of coercive control and they have incredible fear of the other party, you have a big problem and it's abusive. Emotional manipulation. Sometimes the perpetrator has enormous swings in the volume of their voice. Sometimes they're so erratic that it causes this fear. It causes emotional withdrawal from the other parent or the other party, I should say. It destabilizes folks if it's repeated, it's repetitive, and it's used to control. It's awful. Some other things, some other examples. Believe it or not, verbal abuse is a form of domestic violence if it is used to control and humiliate. Not talking about a rare, excuse my French, an F-bomb or a put down, a critical comment. What I'm talking about is a pattern of repeated horrible talk. Talk that's intended to control, to cause fear, to humiliate. This is coercive control. They're patterns. Same with threats. Same with using weapons. Weapons of any kind, knives, guns, flammable materials, you name it, people use it to cause fear. Suicidal ideation. This one continues to shock me, but it happens. Again, not a cry for help, but a deliberate attempt to cause doubt, to cause fear, and to manipulate. It creates victimhood. It can create over time depressive behaviors. It can cause people to be more and more isolated. It can cause, and when I say can, there is plenty of literature that has proven this stuff. Not for me, people smarter than me and the field of social sciences. Low self-esteem, constant criticism erodes people's notion of self-worth. It erodes their confidence to manage their daily affairs, maybe even to represent or to push forward their legal interests. We've seen cases where people are threatened and bullied from hiring a lawyer or bullied into hiring a certain lawyer that the perpetrator is able to control and manipulate. Feelings of guilt and shame get internalized. They cause long-term harm, not just during the proceedings, but beyond. Some more examples. The threats to pets. I already talked about this. It's a terrible thing, and it happens. The social media stuff. This is typically where people are threatening to publish nude photos of their partner or videos that the partners took of each other during happier days. It always surprises me how much of this stuff is out there. It's out there. And if you have an expectation, something is going to be kept private. And if it's sexually explicit, you always do. And somebody either publishes it or perhaps even worse in the context of this discussion, uses the threat of it to gain an advantage to cause fear. It's coercive control. Damaging property to cause fear. Here's some of the impacts from these kinds of behaviors. Perpetrators like to make their victims fearful, dependent on them for their finances, dependent on them for relationships, dependent on them for legal help. These behaviors cause damage, restricting freedom, and some obvious practical impacts. If you cut somebody off from the bank accounts and they can't afford to hire a lawyer or a good lawyer, that's a big problem. We've seen people cut off phone service, take phones, hide devices. These are all practical damages. Impairing decision making. If you are so traumatized that you cease to function as a good parent, then the perpetrator has won. threatening prosecution, forcing criminal behaviors. I'm going to speed up a little bit because I see that we're running a bit short on time. Folks, this causes long-term effects. Sometimes there are unhealthy bonding relationships with the perpetrators. These are long-term scars. Kids have long-term scars. Incidentally, if you've been to one of my webinars before, I should say, you might have heard me say that I care a lot about kids. And when it comes to trauma with kids, the biggest determinant of long-term trauma is not the fact of whether the parents divorced or not. It's if they chose to divorce, or one of them chose to divorce, how much conflict occurred during the divorce. The amount and kind of conflict is the biggest driver of long-term trauma in children. And I guarantee you, if kids are living in a home where coercive control is being perpetrated or any kind of domestic violence, the trauma is almost definitely going to be significant. Next, I want to pause for just a moment and talk about a really important subject that I can't spend enough time on. One of the biggest arguments against using coercive control in our statutes was that you're going to increase the floodgates of false allegations. That probably has happened. And I will tell you that claiming abuse, whether it's spousal abuse or child abuse, is often the nuclear weapon in child custody litigation. It is incredibly profound, the impact it has. And the sad reality is that since domestic violence is a real and scary and terrible thing, it's judges are going to listen to the allegation very carefully. They need to err on the side of safety. It's very difficult to defend against false allegations, very difficult. It's not easy to prove the allegations on the other side, but it's maybe even more difficult to defend against them. The reality is that in most domestic violence cases, there's only two witnesses, the perpetrator and the victim. That obviously has its own inherent challenges. So when you're talking about only two witnesses, we're looking for other circumstantial evidence that either proves or in some cases disproves these allegations. Circumstantial evidence and how judges are looking at this stuff often includes, and what we're seeing in our cases is, it includes records of communications. We don't always have them, and 90% of what happens under the roof of a home happens just verbally. But a lot of times we see evidence of this stuff in text messages, voicemails, social media posts, believe it or not. One of the parenting communications apps, such as Talking Parents, which a lot of judges are requiring high conflict parents to use. A lot of times we see some of these evidence in those behaviors or those statements. Sometimes you have extrinsic evidence that it's occurring, such as criminal charges. Sometimes there's there's medical records, maybe there's hospital records, maybe they're even, psychological records, which are problematical on the scope of tonight's discussion. But again, we're looking at what other evidence is out there that either corroborates or disproves this stuff, and it's not easy, for sure. Sometimes, maybe oftentimes, if there are sufficient resources, we're hiring experts to interview the parties, do psychological testing, conduct it on the children, talk to other witnesses. Sometimes the circumstantial evidence comes from what the victim has told third parties. That is available as well, and experts can talk to those folks as well. So, and coming close to the end here, if anybody within earshot of my voice even thinks they're a victim of domestic violence, here are some resources. Izzy's going to make a copy of this presentation available after tonight. Take a screenshot of this, write this stuff down. There's some important phone numbers on this, but before you get to phone numbers, I always tell people your number one priority is get yourself and your kids and your pets to physical safety, get out of the situation physically if you can, and then call 911. Then you call one of these other hotlines. Take those steps though. With that, I'm going to pause and let me go ahead and turn it over to Izzy.
Awesome. Thank you so much, Rich. All right, we have a lot of questions, so let's just dive right in. The first one is, what do I do if an expert on coercive control is being used in my case, but they have not met me or my children in person? How do I counteract this, or who can be a witness to defend against this?
Questioner, thank you for posing it. And I'll repeat the question. The question this time is, I have a concern about the expert witness that is apparently identifying coercive control, but the expert has not done his or her job, in my opinion, which should include to be interviewing the parties in the case, including the perpetrator or the accused perpetrator. The short answer to that is I would treat that problem like I would treat any other expert witness problem. If there is an expert on the case, and you're opposing that expert, you have an opportunity to cross-examine that expert. You can hire your own expert to critique their report. You can get the records from the files of that expert. There are different ways you can go about trying to attack that expert. And this applies whether it's an expert on domestic violence or an expert on anything else, such as the value of a business. Some of these same principles hold true.
Great, thank you. What if both parents have been domestically abusive in regards to joint decision and parenting time?
The question is another good one. To paraphrase it, what if both of the parents are perpetrators of domestic abuse? How does that in fact impact the custody decision? Well, I don't know the answer to that because it's going to depend on what is going on. I would think that a judge is going to, first of all, try and get to the truth about whether it's indeed the case that both sides have been perpetrators or not. And if they are, the judge is going to need to decide whether it's in the best interest of the children to force joint decision making or to designate one parent or the other as the decision maker with some safeguards in there. Or come up with some sort of hybrid approach, which we're increasingly seeing, where one or both parents are allocated decision making, but then you have a professional that's put on the case after the case is complete, after the hearing is complete, a decision maker or a parenting coordinator, somebody who has continued oversight in some capacity over the family. These aren't easy cases and there aren't great solutions to this kind of thing.
Thank you. All right, we have many along this vein. How do I prove coercive control in court?
So the question of how one proves it is a question that is being answered every day in new ways in our courts in our state. I will tell you how we are handling it in some of our cases. Like I mentioned before, we're looking at some sort of corroboration. We're looking for some other evidence. Now, I always remind people that the most important evidence that a judge is going to hear comes from the testimony, the verbal statements of each party. When a parent goes to court and gets on the witness stand, gets sworn in and testifies and makes statements in response to the lawyer's questions, that is evidence. So you're going to have that no matter what. Each side is going to tell their story. The problem, of course, is you have conflicting stories. You have allegations, denials. You have stories that are made up. You have stories that are exaggerated. You have stories that are dead on true that the other parent denies. So we're looking at some sort of corroboration. We're going to ask our client if they've talked to other people while any of this stuff has been happening. Have they kept a diary or a journal? Are there records that show these behaviors in text communications, talking parents communications, statements in front of other parties? Surprises me, but it happens. People sometimes will do terrible things in public or at family events or at daycares or schools. It happens. What you want to do is try and find all the ways that there are other pieces of evidence out there that could bolster your case. Then let your lawyer try to figure out how to bring that evidence to the judge. Not an easy thing, but it's certainly something that is doable. And I hope that those of you who are listening to the call tonight who are still being victimized are taking some of these statements as tips to use in the future. So if you can find these statements, if you could start keeping a journal, you can even in some situations record the other parent. The rule there, at least in Colorado, is you can record somebody speaking if you're a party to the conversation. They're speaking to you. That is legitimate. You can actually record them, and we've used those recordings in court before. That is fair as well.
All right, we probably have time for one more. This is an interesting one. I'm wondering what to do about coercive control in the post-divorce context.
Question is, what about coercive control post-divorce? So in post-divorce litigation, we call this post-decree litigation because it's after the decree of child custody or divorce. Sadly, many people who have contested divorces or custody cases continue to fight in the courts for years to come, sadly. The way one handles these behaviors after the decree is complete is very similar. There's not that big of a difference. If anything, I would say that there's often more avenues to obtain evidence because if you're involved in a contested case, there's a good chance after the case is complete that there's going to be a third-party professional who's monitoring things and keeping records. There's a good chance that your judge will have ordered you to use one of these parenting communications apps. Talking Parents, Civil Communicator, Our Family Wizard. These are all good ones. If you're using one of those, chances are there's lots and lots of back and forth. These apps can create transcripts that can be used in court. You can highlight portions of those transcripts, and you can use those things to prove the abuse. What I tell people, if they've been a victim and they've completed the case, is continue to be wary, continue to be careful. There's no assurance that the behaviors have ended. In fact, in many cases, the behaviors actually escalate after the case is over. Take the threats seriously, act on them, call the police when you need to, go back to court. You can restrict the other parent's parenting time. You can cite somebody for contempt of court. There's all sorts of things you can do, and you should do in order to prevent the additional victimization. So with that, I'm so sorry. I realized I didn't get to all the questions. This is such an important topic. We will do this again. Let me make that assurance right now. I thank you for joining us tonight. I'm going to turn it over to Izzy and she'll talk to you about how we can help you more after tonight. But for me, again, thank you. I wish you safety. I wish you peace. Have a good night. Back to you, Izzy.
Thank you so much, Rich, and thank all of you for attending. As Rich mentioned, even though we didn't get to all of your questions today, we would like to offer you a free consultation to meet with one of our attorneys and get those questions answered. Just give our offices a call and give them the code WISER together, or just mention the webinar and they'll be able to set you up with that free consultation to get more of those questions answered. I'll reiterate what Rich said. We wish you peace. We hope to see you at another WISER Together webinar. Have an excellent Colorado Wednesday, everybody.